Okay. The committee will come to order, and the chair recognizes himself for an opening statement. In December of last year, EPA put out its final rule for coal combustion residuals. In January, we heard from the states and the utilities about some of the problems with the implementation of the final rule, in particular the fact that the rule is self-implementing. The only mechanism for oversight and enforcement is citizen suit, and state permit programs do not operate in lieu of the final rule. To address those concerns, we went back to the drawing board to find a solution that creates enforceable state permits, but also takes into account the sound technical standards EPA established for coal ash in the final rule. The result of that effort was a discussion draft that will ensure every state has a coal ash permit program containing minimum federal standards that incorporate the requirements from EPA's final rule. We continue to work on a bipartisan basis with our colleagues in the House and our friends in the Senate. Last week we heard from the states and utilities, and today we heard from EPA about the discussion draft. We also received technical assistance from EPA, which they offered again today. The bill we will vote on this week reflects careful consideration of the comments and concerns we heard from stakeholders and EPA regarding the discussion draft. The bill requires every state to have a permit program, and every permit program will contain minimum requirements based on the EPA's final rule. Permit programs will address inactive surface impoundments in essentially the same manner as EPA dealt with them in the final rule, in that they will have to be closed within 3 years or 5 years from the date or enactment, or they will be regulated like an active disposal unit. We heard concerns the timing was not clear regarding when inactive surface impoundments that failed to meet the closure deadline would have to comply with all the permit program requirements. The bill we will vote on tomorrow clarifies all of the permit program requirements will apply to inactive surface impoundments the day after they fail to complete closure by the deadline. The compliance timeframes in the discussion draft are comparable to the deadlines in the final rule, but concern was expressed at the hearing that there were certain requirements in the final rule that would take effect on a significantly shorter time frame than under the legislation. The bill we will vote on changes the deadlines for certain requirements and requires owners and operators prepare fugitive dust control plans, begin conducting structural stability inspections, comply with the requirements for surface water protection and record keeping, and install a permanent marker on all surface impoundments within 8 months from the date of enactment, which makes compliance with these requirements directly in line with the time frames for compliance under the final rule. The bill expressly protects the ability to bring citizen suits by creating enforceable permits. It eliminates citizen suits as the only mechanism for enforcement of EPA's requirements for coal ash. The bill requires states to make information regarding groundwater monitoring, corrective action remedies, and structural stability, as well as emergency action plans, fugitive dust control plans, and certifications regarding closure available to the public. States must also make final permit determinations publicly available and make all documents for permit determinations not only available to the public but also provide an opportunity for review and comment. Because the requirements in the final rule will be implemented through state permit programs, the bill allows the implementing agency to provide certain flexibility that takes into account site-specific risk-based factors. We heard at the hearing that there is no standard of protection in this bill and that states can't or won't do the right thing with respect to regulating the disposal and reuse of coal ash. We heard by allowing states to incorporate the same flexibility they employ in other RCRA permit programs that we are weakening the requirements of the final rule. The fact is, however, that EPA relies on the states for the implementation and enforcement of RCRA, and we heard from the Environmental Council of the States and the Association of State and Territorial Solid Waste Management Officials at our hearing. States welcome the new minimum federal requirements and are up to the task of regulating coal ash. This is a good bill. EPA developed technical requirements for coal ash that are protective of human health and environment. This bill utilizes those requirements and makes them part of an enforceable permit. I urge my colleagues to vote yes. With that, I yield 5 minutes to the gentleman from New York, Mr. Tonko.
Thank you, Mr. Chair. I realize that a number of our colleagues have worked on the issue of coal ash disposal for a number of years. The attention to this issue is warranted by the fact that coal ash is one of the largest industrial waste streams produced in our country. And the attention is needed because of the significant damage to communities, to personal property, to businesses, individuals, and the environment caused by spills from coal ash disposal facilities that were poorly designed and poorly maintained. For many years, the Environmental Protection Agency had not acted to address the many issues raised by stakeholders. And there was ongoing uncertainty about the status of coal ash and just how the agency might proceed to regulate it. That was then, and this is now. The situation had changed with the publication of EPA's final rule on the disposal of coal ash last December. While each of us might prefer some different approach to the one taken by the agency, the rule is a positive step that provides certainty to the regulated community and reassurance to the communities near coal ash facilities. EPA is to be commended for its extensive process of public engagement on this issue. The agency sorted through over 450,000 public comments submitted during the public comment periods on the rule and held 8 public hearings in communities across our country. EPA's rule is responsive to industry concerns that classifying coal ash as hazardous waste would harm coal ash recycling efforts that utilize coal ash in new materials and new products. And it is responsive to the concerns of public health and environmental advocates. For the first time, we have federal standards for coal ash disposal sites that will set a floor of protection for all communities. With this rule, states and utilities can begin to address deficiencies in disposal operations. Communities will have access to information about coal ash disposal facilities in their areas, and operators of these facilities will be held accountable for damage caused by improper waste handling. Ultimately, the only real test of whether this rule takes the correct approach or not is by implementing it. The bill before us claims to mimic the protections offered by EPA's final rule, but that claim is in serious doubt. The claims made about the rule, that it may lead to dual enforcement or excessive lawsuits, may prove to be true or prove to be not true. The rule may not provide sufficient protection for public health and the environment. At this point, that is all speculation. If there are problems with this rule, Congress certainly retains the right to legislate a solution to any problem that unfolds. But legislating at this point, especially through a bill that does not provide uniform standards for all disposal facilities, comprehensive monitoring, and transparency in facility operations, is premature. Changes in regulation or in law take a long time, and hitting the restart button now will only lead to continued uncertainty and continued risk. We have had far too much of those already. I do not think we should reject the agency's effort out of hand. This rule rests on the extensive public engagement and negotiation process and years of work invested by the interested parties and the agency. The rule should move forward. We should give this approach an opportunity to work and respect the time and the effort of all the stakeholders who participated in this process. The Improving Coal Combustion Residuals Regulation Act is premature, and we do not need legislation that simply codifies the current state-based system that has not worked. At this point, I cannot support this bill, and with that, Mr. Chair, I yield back.
Gentleman yields back his time. Chair now recognizes the gentleman from Ohio, Mr. Latta, for 3 minutes.
Well, thank you, Mr. Chairman, and thanks for holding this meeting today for our opening statements. And I'm pleased that we are going to be marking up the Improving Coal Combustion Residuals Regulation Act of 2015. This important bill will provide greater clarity and confidence on coal ash regulation and disposal. Under the EPA's final coal ash rule, states and owner-operators have expressed concern about 2 sets of requirements, self-implementation and enforcement being through citizen suits, most likely leading to different regulatory interpretations and potential further federal regulation. In states like Ohio, coal provides just under 70% of net electricity generation. EPA has previously completed 2 regulatory determinations that coal ash is not warranted under Subtitle C as hazardous. Given this and the numerous regulations being placed on the coal and energy industries, I believe it is imperative that coal ash is regulated in a safe manner and that provides clarity and greater confidence so we can continue to ensure our national energy growth and affordable energy for all Americans. The Improving Coal Combustion Residuals Regulation Act of 2015 achieves these goals. Furthermore, witnesses have testified before this subcommittee about states being in the best position to implement permit programs for their respective states. And I am pleased that the legislation takes this important approach. I urge my colleagues to support the bill, and Mr. Chairman, I yield back. Thank you very much.
Gentleman yields back his time. The chair now recognizes ranking member of the full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. This subcommittee has now held 3 days of hearings this Congress on the important topic of coal ash, including a hearing with EPA just this afternoon. Unsafe disposal of coal ash presents serious risks to human health and the environment, and this subcommittee should continue to hold hearings to understand these risks. In January, the subcommittee heard from EPA and stakeholders about the agency's new final rule. After years of debate at the agency and in Congress over the proper regulation of coal ash, the agency had reached a verdict. EPA's final rule reflects a tremendous effort, and it will, for the first time, provide the framework for addressing this serious environmental problem. This rule is the product of a robust public process, including field hearings and several rounds of public comment. It reflects the input of over 450,000 commentators, including states, industry groups, environmental groups, and individual concerned citizens. In the end, EPA finalized a rule that addressed almost all of the concerns this subcommittee has heard about for years. Those in the coal ash recycling industry who make things like concrete and wallboard substituting coal ash for virgin material had sought a non-hazardous rule under Subtitle D of RCRA, and that is what they got. Those in the electric utility industry wanted a Subtitle D rule that would not require them to retrofit their existing impoundments with liners, and that's what they got. States wanted a mechanism to set up their own programs to implement federal standards and have EPA approve them, and that's what they got. And the only stakeholders who really did not get what they sought in this rule were the environmental and public health advocates who wanted a stronger Subtitle C rule with a requirement that the giant unlined pits currently receiving this dangerous waste be retrofitted to protect groundwater. The testimony at the hearing last week and earlier today reflected those truths. That testimony also raised serious concerns about this bill and the ways it would undermine public health protections. But still, we find ourselves just 3 hours later marking up the legislation. This new proposal retains the problems of past proposals, which have been discussed extensively in this subcommittee. Previous CRS reports on those proposals are still relevant, simply because the problems cited have not been addressed in the new bill before us. This bill would create a new model of delegation at states with a sharply curtailed role for EPA. It does not include a legal standard of protection, a substantive EPA role in reviewing state programs, or EPA backstop enforcement authority. The bill also falls short in terms of the technical requirements for coal ash disposal because necessary health protections included in EPA's final rule are left to state discretion or left out entirely. Groundwater monitoring and protection, closure requirements, cleanup requirements, all could be weaker under this bill than under the final rule. If anything, we should be strengthening the protections in the final rule, not weakening them. I think this legislation is unnecessary and dangerous for public health and the environment. I applaud EPA for their hard work on the coal ash final rule, and I hope that this subcommittee can move forward in an oversight role as implementation begins. I yield back, Mr. Chairman.
Gentleman yields back his time. Chair now recognizes the gentleman from Texas, Mr. Green, for 3 minutes.
Thank you, Mr. Chairman and Chairman Chimkus and Ranking Member Tonko. Thank you for holding today's markup on the Improving Coal Combustion Residuals Regulation Act. Our subcommittee has looked at this issue of coal ash for the past several Congresses, and I've long argued that the coal ash needs to be regulated under Subtitle D of the Resource Conservation and Recovery Act, RCRA, which would ensure that the recycling of coal ash continues without disruption. The beneficial reuse of coal ash is responsible for tens of thousands of jobs throughout the country in helping our economy and our environment. I've supported bipartisan legislation in previous Congresses that would ensure the coal ash be regulated under Subtitle D, and I'm happy to see that the EPA, through its rigorous multi-year rulemaking process, agreed that coal ash should be regulated as a non-hazardous waste. I do have some concerns with the final rule, and I respect the views of EPA who testified earlier today on this matter, but I believe that a state-based permit program would be the best way to go forward. A state-based permitting would be more sensitive to unique conditions found in the individual states and avoid the final rules citizen suit only enforcement mechanism. With a state permitting program, the authorizing agency would be empowered to enforce and have an immediate impact on the health and safety of the citizens it's charged to protect. I will support the bill during our subcommittee markup for these reasons, as well as the importance of moving the process forward. However, I do have some reservations with the draft. Stakeholders have testified that the draft would weaken health and safety protections contained in the final rule, include public disclosure requirements. Before this legislation is considered before the full committee, these concerns need to be addressed. You know, my friends in the majority will be open to working with me and like-minded colleagues in making this effort truly bipartisan. Again, thank you, Mr. Chairman and Ranking Member, and I yield back to balance my time.
Gentleman yields back the balance of his time. The Chair reminds members that pursuant to the committee rules, all members' opening statements will be made part of the record. Are there further opening statements? Seeing none, the Chair calls up the committee print and asks the clerk to report.
Discussion draft to amend Subtitle D of the Solid Waste Disposal Act to encourage recovery and beneficial use of coal combustion residuals and establish requirements for the proper management and disposal of coal combustion residuals that are protective of human health and the environment.
Without objection, the first reading of the bill is dispensed with, and the bill will be open for amendment at any point. So ordered. For the information of members, we are now on the committee print. The subcommittee will reconvene at 9:30 a.m. tomorrow morning. And I remind members that the Chair will give priority recognition to amendments offered on a bipartisan basis. I look forward to seeing you all tomorrow. Without objection, the subcommittee stands in recess. That was a good y'all. Y'all, I know I was trying to shorten it up, but
Even a guy from Southern Illinois says y'all.
The problem. In other words, if you have if states have the flexibility, then there is no federal floor of protections. And I know that some on the other side have suggested that that they want to have the minimum requirements in EPA's final rule incorporated into the bill. But as the gentleman from West Virginia says, that isn't the case. So, I mean, he's being honest about that, and I appreciate it. But if you go along with what he's suggesting, then the bottom line is that we don't have the federal floor protections. I yield back.
Gentleman from New York, yield back. Thank you. I'd like to recognize myself for 5 minutes in opposition. So the whole thing that we're trying to do is take the reg, put it into federal code, make it law, under the testimony that we've heard, that for it to be applicable, it has you have to have discretion by the states, very similar to the discretion afforded by the municipal solid waste regulations. So we're just doing what we've done in the municipal solid waste, and we're just applying it to coal ash. The EPA has been very helpful. so that coal ash is no longer being labeled as toxic. But now the whole intent is to have minimum standards with a certification program that the states can then comply to. There is a minimum standard, and it's again simple. So what my colleague attempts to do is just force the implementation of the reg without the flexibility. And the flexibility, as testified, is key for the states to be able to do the job they're being asked to do. So I appreciate the concerns of my colleague.
Would the gentleman yield?
I would yield.
I mean, I'm just trying to make a point here, and I think the point's been made, which is that the bottom line is the way this bill reads without my amendment is that states can pretty much do what they want. I mean, it's true that generally speaking, with most EPA regulatory schemes or process, and in my own state of New Jersey, we have so much industrial pollution from the past that that states are allowed flexibility, but they have to meet certain minimum requirements. And what you're saying with this bill is that there are no minimum requirements. States have the flexibility basically to do what they want. And I think the gentleman from West Virginia was pretty honest in saying that, and I think that's exactly what's going on here. So I understand what the chairman's trying to say, but I mean the bottom line is if the flexibility exists and there's no minimum requirements, the states can.
But we're claiming there is minimum requirements. That's the whole aspect. And when we tried to get the EPA assistant administrator to confirm section by section, he in essence refused to do so. So we've taken right out the code because a final rule is self-implementing. EPA did not include certain elements from the June 2010 proposed rule that would have allowed modification of certain requirements based on site-specific factors because of the absence of a state regulatory oversight. Because the draft legislation would require EPA's rule to be implemented with either state or EPA regulatory oversight, the bill restores the ability of the implementing agency to modify in limited instances elements of the rule to take into account site-specific risk-based factors, which is, again, similar to what we do in the federal municipal solid waste regulations in Part 258.
Well, Mr. Chairman, if you just yield, I just don't see how there's any real standard under the circumstances you described. But look, I think we've debated this enough. I'm not going to keep going.
No, it's fine, and I appreciate that. I'll yield to Mr. McKinley.
Just again, in the remarks that were made yesterday, and they were not refuted, and that was that this draft legislation includes all of the provisions of the final rule, except for two provisions. One was a notification requirement, and the publicly accessible Internet site requirements. Other than that, it's the rule. It's what they passed.
Again,
Mr.
Chairman,
Let me reclaim my time yielding to the ranking.
I guess, it just seems to me that if we don't have any standard, or if the standard can just be waived, then I don't know how you have any standard or minimum requirements. But anyway, I think we've made the point, so I'll leave it alone at this point.
Yeah, I appreciate the comments, and thank you for those. Anyone else wishing to speak on the amendment offered by the gentleman from New Jersey? If there are no further discussions, the vote occurs on the amendment. All those in favor so signify by saying aye. Gentleman requests a roll call vote. We'll conduct a roll call vote.
Mr. Harper? No. Mr. Harper votes no. Mr. Whitfield? No. Mr. Whitfield votes no. Mr. Pitts? No. Mr. Pitts votes no. Mr. Murphy? No. Mr. Murphy votes no. Mr. Lotta? No. Mr. Lotta votes no. Mr. McKinley? Mr. McKinley votes no. Mr. Johnson? Mr. Bouchon? Mr. Flores? No. Mr. Flores votes no. Mr. Hudson? No. Mr. Hudson votes no. Mr. Kramer? No. Mr. Kramer votes no. Mr. Upton? No. Mr. Upton votes no.
I think the member needs to be in the chamber.
Mr. Johnson? No. Mr. Johnson votes no. Mr. Tonko?
Yes.
Mr. Tonko votes yes. Mr. Schrader? Yes. Mr. Schrader votes yes. Mr. Green? Ms. DeGette? Ms. Capps?
Votes yes.
Ms. Capps votes yes. Mr. Doyle? Mr. McNerney? Yes. Mr. McNerney votes yes. Mr. Cardenas? Mr. Pallone?
Yes.
Chairman Shimkus.
No. Clerk will report. I believe the gentleman is not recorded.
Mr. Green votes yes.
We did okay. Any other members wishing to vote? Will the clerk report?
Mr. Chairman, on that vote, the yeses were, or the nays were 12 and the nays were 6. What?
Let's do that again.
My apologies. The noes were 12 and okay. No,
Take your time.
the yeses were 6 and the noes were 12.
So, the nays prevail. The amendment is not agreed to. Are there any amendments to the bill? For a person, gentleman, lady from California, rise.
I have an amendment at the desk.
The clerk will report the amendment.
Number 1. Amendment to discussion draft offered by
Ms.
by
Capps.
Mrs. Capps.
The gentlelady is recognized for 5 minutes in support of her amendment.
I have this amendment is to the bill, the Resource Conservation and Recovery Act, which has a simple purpose: to protect public health and the environment from unsafe disposal of solid waste. Regulations for municipal solid waste must include criteria necessary to protect human health and the environment. EPA's new final rule on coal ash also embodies this protective standard, but this bill before us would eliminate that standard for coal ash. If this bill is adopted as is, coal ash will be the only waste not held to a standard of protection under RCRA. Not only does this bill exclude some of the requirements EPA deemed necessary in the final rule, it provides significant discretion to the states. And importantly, when EPA reviews the sufficiency of state permit programs under this bill, it cannot even ask whether or not the program adequately protects public health and the environment. Yesterday, one of my Republican colleagues asked what the difference is between the discretion given for municipal solid waste programs and the discretion that would be given under this bill. The legal standard of protection is that difference. Under current law, state municipal solid waste programs are reviewed by EPA against a legal standard of protection. In contrast, permit programs under this bill would not face the same review. My amendment would fix this by holding state coal ash programs to the same legal standard as state municipal solid waste programs. And it wouldn't be hard for states to meet this standard, because in its final rule, EPA laid out a template for a program that meets this standard. This is a simple amendment that to ensure we are doing what is necessary to protect human health and the environment. Without it, the health of our families, communities, and our environment are at risk. I ask and urge my colleagues to join me in supporting this amendment, and I have time to either yield back or yield to any of my colleagues. I yield. Okay. I yield to my colleague, Mr. McNerney.
Thank you, Mr. Capps. I want to urge my colleagues to support this very simple but important amendment. There seems to me this morning we've seen a basic disagreement about whether the bill provides a floor or not. And so what this amendment does is make sure that we have a floor. When authority is delegated to the states under the RCRA, the states are held to legal standards of protectiveness. These standards are the yardsticks by which is determined whether a state's efforts measure up, and they ensure a consistent level of effort and protection throughout the nation. This approach has worked well because it ensures that every American family enjoys a basic level of protection, a floor. It prevents a race to the bottom among the states in which a state willing to have the laxest protection becomes a dumping ground for the neighboring states, and it prevents unfairness of one state allowing a facility within its borders to contaminate an adjacent state. The CRS has identified the lack of standards of protection in previous versions of coal ash legislation as a significant issue. The bill we are considering today has the same basic fundamental flaw, a lack of standard of protectiveness. This bill contains no consistent national standard to protect against the risk of coal ash and no guarantee that states' programs will be protective. The risks from coal ash are real, they are significant. We should be working to address them, not insisting on legislation that is flawed. The American people deserve better. While I don't support this legislation, I think the amendment will go a long way to make a big improvement. And again, I urge my colleagues to vote yes, and I yield back to Ms. Capps.
I yield back.
Gentlelady yields back time. Anyone speak? Mr. McKinley seeks recognition. 5 minutes to speak, I believe, in opposition to the amendment.
Thank you, Mr. Chairman. I find this interesting with this provision because there are some people saying we don't need this legislation at all, and the rule should be able to take into effect. But they're saying the rule may not go far enough. I think it's interesting because it comes from the EPA. That brings us back to this amendment. It brings us back to where we were 4 years ago, and to insert protect human health and environment as a subjective standard into this minimum requirements that the EPA has set up, and we're adopting into this, serves as a federal baseline for protection in the legislation. The minimum requirements were crafted in such a way, in coordination with the EPA, that we set up a federal guideline to provide those safety to protect human health and the environment. They already are in that because they set the rule. And we're trying to adopt the basis of the rule as the basis for where we go with this. So I appreciate my colleagues' concerns. We've had this amendment many times before, and the effect of adding, quote, protect human health standards into the minimum requirements is still the same. It's an attempt to set up a subjective yardstick for litigation. The federal district judges, the EPA, are going to get, we establish confusion with this issue, and it allows litigants to get into this and challenge it. The EPA has the tools in this. If they think this permit is failing to meet the minimum requirements for health and safety, the legislation gives the EPA specific criteria to address and access that state permit to be protective. So I would urge the rejection of the amendment. Yield back my
Gentleman yields back his time. I'm sorry, I didn't know she wanted to get time yielded. Mr. McKinley, will you yield time to the gentlelady from California?
Yes.
You have remaining.
Thank you very much for yielding. And I just want to make the point, as a public health nurse for many, many years, I do believe this nation does have standards of public health, and that these are not subjective, but breathing clean air and drinking clean water, and certain standards have been held. I know this is about a debate about what those standards should be, but it's certainly, I hope, understood that we do have a role to play in Congress and in the public health system for setting standards of health and safety. And I will yield to a colleague, or I'll yield back.
The time is gentleman from West Virginia. So
I hear that, and I think that's what this legislation is trying to provide, is give the states using the minimum. If you in California want to have a higher standard for air and water quality, then set the standard. But there's going to be a minimum standard that is set in the rules and regs. They've already passed the final rule to take care of this. So I think it's resolved. If you want to make it more stringent for your health, that's the option of California to be able to do that. Other states may want to have something that's slightly different, but not below the minimum. So I yield back my time.
gentleman yields back his time. Anyone? Any other member seeking recognition on the amendment? Seeing. Okay. Gentleman is asking for a roll call vote on the amendment offered by the gentlelady from California, Ms. Capps. A roll call will be conducted. Will the clerk call the roll?
Mr. Harper. Mr. Harper votes no. Mr. Whitfield. Mr. Whitfield votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Murphy. Mr. Lotta. Mr. Lotta votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Johnson. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Upton. Mr. Upton votes no. Mr. Tonko.
Yes.
Mr. Tonko votes yes. Mr. Schrader. Mr. Schrader votes yes. Mr. Green. Mr. Green votes yes. Ms. DeGette. Ms. Capps. Ms. Capps votes yes. Mr. Doyle. Mr. Doyle votes yes. Mr. McNerney. Mr. McNerney votes yes. Mr. Cardenas. Mr. Cardenas votes yes. Mr. Pallone. Mr. Pallone votes yes. Chairman Shimkus. Mr. Murphy votes no. Mr. Chairman, on that vote, there were 8 ayes and 12 nays.
The vote is 12 nays and 8 yeas. The amendment is not agreed to. The question now occurs on forwarding the committee print to the full committee. All those in favor shall signify by saying aye. If you're requesting that. Right. All those opposed, nay. The ayes appear to have it. And the gentleman from New Jersey requests a roll call vote, so the clerk will call the roll.
Mr. Mass. Chair.
Yes, the chair recognizes the gentleman from New York.
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. I oppose this legislation, and I urge my colleagues to join me in opposition. In past Congresses, we were told that EPA wanted this bill to close gaps in its authority under Subtitle D of RCRA. Well, now we hear that EPA thinks their authority is strong and has no gaps. The witness yesterday reiterated that point. In past Congresses, we were told that this bill was necessary to ensure that EPA would not regulate coal ash as hazardous and restrict beneficial reuse. Well, EPA reiterated yesterday that they're not regulating coal ash as hazardous and they are not restricting beneficial reuse. We all heard Mr. Stanislaus say that EPA is not doing so now and they have no plans to do so as we move forward. We can all agree that coal ash can pose serious risks when not disposed of properly. Now, for the first time, we have minimum federal requirements that set a floor of public health and the environmental protections. The old arguments are now moot, but still some are pursuing legislation. Why? Well, now we're told that Subtitle D will not include effective enforcement. In fact, we're being told that by stakeholders who specifically sought a Subtitle D rule. Importantly, EPA is not concerned about the enforcement of its rule. We heard just yesterday that it expects strong enforcement through a combination of citizen suits and state adoption of the requirements. Now we're also hearing that the rule will lead to dual enforcement. Too little or too much, it seems the advocates cannot decide. But again, EPA is not concerned about this potential problem. As we heard yesterday, EPA believes it has effectively addressed any concerns about dual enforcement by establishing a mechanism to review and approve state plans. So the old arguments for this legislation are now moot and the new arguments purely speculative. EPA has confidence in its final rule, and so do I. We should not overrule the public process that we went into it and undermine its protections. I urge my colleagues to vote no on this bill, and with that, Mr. Chair, I...
Gentleman yields back his time. The clerk will now call the roll.
Mr. Harper. Aye. Mr. Harper votes aye. Mr. Whitfield. Aye. Mr. Whitfield votes aye. Mr. Pitts. Mr. Pitts votes aye. Mr. Murphy. Mr. Murphy votes aye. Mr. Latta. Mr. Latta votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores. Mr. Flores votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Kramer. Mr. Kramer votes aye. Mr. Upton. Mr. Tonko.
No.
Mr. Tonko votes no. Mr. Schrader. Aye. Mr. Schrader votes aye. Mr. Green. Aye. Mr. Green votes aye. Ms. DeGette. Ms. Capps. No. Ms. Capps votes no. Mr. Doyle. Yes. Mr. Doyle votes aye. Mr. McNerney. No. Mr. McNerney votes no. Mr. Cardenas. No. Mr. Cardina votes no. Mr. Pallone. No. Mr. Pallone votes no. Chairman Shimkus.
Aye.
Mr. Chairman Shimkus votes aye. Mr. Chairman, on that vote, there were 16 ayes and 5 nays.
16 ayes and 5 nays. The ayes have it. The bill is agreed to. Without objection, staff is authorized to make technical and conforming changes to the bills reported by the subcommittee today. So ordered. Without objection, the subcommittee stands adjourned.